Okay, good morning. This is Richard Hsu, host of Hsu Untied. Today, I'm very pleased to have with me as my guest Eliot Williams, who's a partner at Baker Botts. Eliot, welcome to the program.
Richard, thanks. It's a real pleasure to be here.
So, Eliot, let me start by asking you, how you got into electrical engineering, being a double E degree person myself. I'm always interested in knowing how people start that career.
It goes way back. I would say, when I was in kindergarten, my dad had quit his job to go to college and was studying civil engineering. And so, he would come home and start teaching me some of the things he was learning the best he could. Obviously, I was probably 5 years old at the time, but I always found, a lot of the science and math of that fascinating. And as I got older, I really got attracted to high tech things. I wanted to know how my telephone worked, how the TV worked. It was all sort of magic, obviously, and to some extent still is. But that's really what I think got me most interested in pursuing double E. I had an aptitude for math. I recommend that you work on your math skills because you will be using them extensively. So that made it kind of an easier path than some of the other disciplines I could have picked. But certainly, engineering in general was always interesting to me. People that were able to, sort of go off into the darkness and come back with a solution to a problem and some great new invention. It always sort of fascinated me that people could do that. And that got me interested in double E.
Any particular area of double E? Obviously, analog circuits, integrated circuits, digital circuits. What did you?
Yeah, so what I wound up pursuing at and I went to Texas A&M, which is a great school, great double E department. What I wound up spending most of my time on was signal processing, communications, control systems. That interested me the most. But it was a pretty broad curriculum. You had to also take electronics and power electronics and understand the basics of double E across the board. And I would say, overall, the class I wound up enjoying the most was my senior year practical course that was co-listed with the biomedical engineering department, I think, on magnetic resonance imaging machines. And once I learned how those things worked, it was just, it seemed incredible that someone had come up with that idea and been able to actually make it work in practice. And it always seemed magical to me. So that was that was the path I pursued. And I don't know if you would call, MRI certainly kind of a hybrid of signal processing as well as some, even electromagnetic, I guess, larger antenna design, things like that. So it was an interesting mix. It really took that whole curriculum and put it together in a way that I thought was probably useful to me and kind of understanding how all of electrical engineering could come together to make something really important and useful.
Well, definitely the signal processing stuff. That's definitely the mathy end of electrical engineering. So I definitely remember, Fourier transform and so forth. So I know that's pretty math heavy.
Yeah, and my favorite was take a really complicated set of differential equations that would take you, days to try to figure out and do one transform on it. An eighth grader could do was amazing to me. Again, and double E, all those math, those tools. But yeah, there's a lot of it, and be ready for that.
I remember I was taking a microprocessor class, programming a microprocessor, and I got completely stuck in that. And if my TA hadn't helped me figure that out, I'd probably still be down in that basement trying to figure out from that class.
Yeah, it was not an area that I spent a lot of time. We had to take computer science courses, obviously, and I took a class in real-time digital signal processing, which did require you to get down into the weeds of programming these DSPs using its native assembly code.
Yeah, exactly. That's what
it was challenging.
Yeah, definitely assembly code. It's following the ones and zeros. It's not like high level Java or anything like that. So.
No, I don't even think Java existed when I was in undergrad, but we had programming languages that were higher level than assembly, but I don't remember learning Java.
So tell me how you have this electrical engineering degree. What made you decide to go to law school? Was that a last minute decision, or was that all part of the plan?
It's probably both. I certainly pursued, I looked at other options before going to law school, but honestly, going into the undergraduate program, law school was certainly on the menu for me. I had spent at least 4 years of high school doing public speaking and debate competitions and knew that I enjoyed it, liked arguing, and so being a lawyer was an obvious path to consider. But, you know, I was still open to going into engineering as I got to the end of my undergraduate degree, and, you know, considered some jobs in the field, but ultimately decided that, you know, I really did want to pursue law school, at least briefly. And that seemed like a good time to do it for me. So I did wind up going straight through. And, you know, in retrospect, I don't know if that was the best path or if I'd recommend that to other people, but it worked for me. So I just sort of continued down the path after finishing law school.
How did you like law school compared to being an engineering undergrad? What would you say about it?
Yeah, it's definitely a different. It definitely is a different mindset that you have to get yourself into to do law school after an engineering degree, because, you know, I remember coming out of, you know, my engineering professor's offices at office hours when they would have given me, you know, some horrible grade on an exam, and I would sit there and I'd say, well, look, I did everything right until I got to this integral that was really hard, and I just moved on because, you know, you can figure that out later. And he's like, we're engineers, we have to get to the right answer. And, you know, so I understood that was the sort of paradigm of being an engineer. You get to the right answer, and law school, you have to strip that out of your head, because you learn quickly in law school that's not the point, that maybe there are even no right answers, but at the very least you need to understand both sides of an argument, you know, extensively, and explore all of them. And so getting there took me a while. I mean, I don't know, you know, a semester to sort of get the gist of what it is that we were doing in law school. But, you know, overall, I certainly enjoyed it. I mean, the subject matter is very intellectually stimulating. I mean, I had a particular interest in antitrust and patent law, and both of those areas are very complex, a lot of rich doctrine. So it was a lot of stuff to learn, and intellectually challenging. You know, it is the reason I sort of hesitated that, you know, when I said, was it best to go through directly from undergraduate, I'm not sure. I certainly think I would have benefited from having been, you know, out in the real world working a little bit more before I went to law school. And so I do recommend that to people when they ask me, you know, should you pursue law school right after undergraduate? I sort of discourage it, but I mean, I understand why people do it. And if that's really what you want to do, you know, go do it.
Mm-hmm. Now, you obviously went into a career of patent law. Was that something you knew going into law school, or did you kind of get pushed into it, or what would you say?
No, I mean, I was interested in patent law before I went to law school. I mean, I knew of patent law. I had a distant relative who I never met. He died before I was born, but who was a patent lawyer. And so I heard stories of what he did, and it sounded interesting. But after law school, certainly. And, you know, as you know, I went to Cravath first, which if I was looking to do exclusively patent law, that's not a firm I would have gone to, you know, because they don't sort of specialize in that way, although there's some partners there that do now, certainly. But to me, I was really interested in litigation. I mean, that was coming into law school, I was more focused on just that, understanding how to litigate a case. You know, when you've got a dispute, you know, you need to learn a lot of skills to litigate a case well, but most important of which is, you know, storytelling. How are you going to tell your client's story? How does it fit in with the law? Who is your, you know, target audience, and how are you going to convince them that your client's views are right? That was really what interested me about the law. You can do that in patent law, of course, which we do all the time. I do that every day. Yeah. But you can do that in other areas too. I mean, you can do that in car wreck cases. I mean, there's really no end to the number of ways you can use that skills as a lawyer. So I didn't really want to specialize. I mean, originally I didn't really want to specialize in patent law. I didn't know if that's what I wanted to do, and I wanted to explore the other options. And that's how I wound up at Cravath doing, you know, general litigation, a fair amount of antitrust litigation, which again, it was an interest of mine. I wanted to explore, and I'm glad I did. But after about 2 years, it became clear that the market really wants me to go into patent law, because there's just, you know, the double E lawyers, you know, there's a fair number of them, but all of them pretty much do this because there's a big market need for it.
Yeah. So then how did you sort of evolve to become you're now a PTAB specialist, or is that, how does that, I mean, how did that kind of evolve?
Somewhat by accident. Sorry, one of my kids is outside screaming, so I apologize for the audio. But that happened almost by accident. I mean, the PTAB didn't exist, of course, when I started practicing in IP. I started doing patent law full time in 2001, and the PTAB wasn't a thing until 2012, 2013, after the American Defense Act passed. Right. So when the PTAB started to hear cases, I got involved in some of them early on. That has to do with there's a long story there, but it has to do with the fact that I had actually testified before Congress regarding the American Mints Act before, after the bill passed, but before these sort of PTAB trials started. So I had a little bit of credibility, market credibility from that, and started getting some cases in the PTAB and, tried it out. I thought it'd be an interesting forum to litigate in. And, I just sort of took to it instantly, I think, because for a lot of reasons. One is you're still doing the important technical stuff of analyzing patent, analyzing the prior art, understanding how those things fit together, telling a story about whether the patentability of the patent or why the patent's invalid over the prior art. So you're able to use all of those skills, but you're able to do that in a very focused way where you're really just focusing on the technology. Whereas in district court litigation, that's an important piece, but there's a lot of other things as well. So you have just the sort of mundane discovery disputes that are day to day and sort of draining that have that in the PTAB. And of course, then there's damages and other issues that get decided in a district court proceeding that they don't have to deal with. Yeah, I like it because I can focus really on just the core technical dispute. And that's the part, obviously, that appeals to me with my background in electrical engineering and as a lawyer. Those are the things I like, and I get to do that pretty much all the time. So for me, it's great.
So is that all you do now, or do you still do some district court litigation as well?
It would depend on what you mean by district court litigation. I still have one legacy case that I was working on even before the PTAB that started in district court and has gone back. It's gone up to the federal circuit and back down again, and it's going up to the federal circuit again. So I still work on that case. But the rest of the cases, I'm really focusing on the PTAB side, even though I'm obviously working closely with the attorneys who are working on the district court litigation. So, I mean, I have a foot into the district court litigation side of the case, but usually don't do much there other than just sort of listen to what their strategy is and sort of talk about how that's going to interact with what I'm doing in the PTAB.
What is the most complicated technology you've had to try to understand in your practice, in your history, your career? A biotech case I took on a few years ago having to do with, very complicated chimeric genes that were being spliced together to make an enzyme that's used in animal feed was by far the most complicated case I've ever touched. For me, I would say that was the hardest for me. Whether it's most complicated or not, I guess, is a subjective question. Other people may have found that really easy, but coming at it from a double E background, there was a lot for me to learn. I do extremely high tech cases all the time involving very complicated coding, like error correction coding and satellite transmissions. It's extremely complicated mathematically, but I sort of understand it easily. That biotech case I think was the most time learning the technology, and I really hadn't known much about at all, but it was also a lot of work. Do you do a good mix of life science and biotechnology, or that was a rare thing? And what is your mix of technology that you do now?
Yeah, I take on cases that that case was a little bit unusual. Most of my cases are in the high tech double E space. Some of them have chemistry aspects to them as well, because it's pretty, it's not at all unusual that you'll run into a chemistry issue in a double E case, either because it has to do with LED and you're building a semiconductor and how do you get the band gap right where you want it. Those are sort of interesting chemical questions that come up from time to time. And then I also do medical device work. So, but those are often a mix of mechanical and electrical components. So it's not really that far away from my core technical competence.
Yeah. Do you think clients appreciate your technical background? Like, do they see that, or do they often know that? Can they see that? Oh, wow, you seem to know more than the average lawyer.
Well, yeah. I hope so. It's an interesting question as to how important it is, because every case by definition is going to involving patents is going to be some new technology, something that didn't exist a few years ago. So I'm always having to learn. I think it's more efficient for the client to have someone with my background, because obviously it's quicker for me to pick up a new subject matter that I haven't seen before if it's related to double E work that I have seen. And so it's a little bit more efficient, which I think the clients appreciate. At the end of the day, I think to do this job well, you really need to understand the technology, because again, it is storytelling. And especially in the PTAB, I'm telling this story to people like me. They're all patent lawyers. They've all got an engineering or science background. And, they're not just going to skim along at the surface. They're going to dig into the real nuts and bolts of the technology. And you absolutely have to understand that to succeed at the PTAB, but you also have to understand how that technology, how those technical details support your story. And so I think it would probably be a bad idea to try to argue in the PTAB the way that someone who doesn't have a case in district court to a jury. It just doesn't, I think, go over.
How does in what primary ways does the PTAB hearings or trials, I'm not sure what the word is, for the validity, and how does that differ from doing, a validity, case in court? I mean, what are the primary differences, would you say?
So the main one by far is the fact finder. I'm tailing my arguments again to people like me as opposed to a jury. Best case scenario in a jury trial, you're going to have one person has some engineering or science background and the rest will not. And so you're going to have to simplify the technology. Both sides will have to simplify the technology, and that's fine, but it certainly has an impact on the actual issues that get put to the jury to decide. Mm-hmm. In the PTAB cases, there is no simplification of the technology. You're going to get into the real details of the technology. So that's one big difference, just because the fact finders are different. The way that the quote unquote trial happens in district court is obviously much different, because witnesses will come in and testify in person and be cross-examined in person. Mm-hmm. That doesn't happen at the so we do that work. The witnesses will present testimony through written document, and then there'll be a deposition where we take their cross-examination, and so there'll be a transcript of that. So you'll see the PTAB judges have access to it, and will use that in their decision, but it doesn't happen in real time in front of them at the trial. The trial takes place over the course of essentially, and it usually lasts about 2 hours, where both sides present their view of the case. There is another important difference, which is just what the standard of proof is. So in district court, to invalidate a patent requires clear and convincing evidence, whereas in the PTAB, it's just preponderance. So that makes the job of the patent challenger a little bit easier.
Yeah, for sure. Now, are you doing the PTAB trials virtually now, or you're going back in person now?
So far, everyone I've done since COVID began has been virtual. The PTAB is open for business, and they will do in-person ones. But I have not done one yet. Essentially, if either side asks for it to be virtual, then the board will do it virtually. It's actually not that big of even PTAB. And just so your audience understands, most often there are 3 PTAB judges that hear each case, and so you're presenting to 3 judges. Even before COVID, it was probably 95% of the time at least one judge. Way. So you're already kind of used in the PTAB to presenting these arguments over Zoom or over video conference. And actually, I find it a little bit easier to do it from home, because I just have better access to the materials that I need when I'm sitting at my desk, rather than up at a podium in Alexandria.
Oh, so you're saying even before the pandemic, you were doing them by Zoom already?
No, before the pandemic, we would have to go into the PTAB hearing room, usually in Alexandria, and one of the judges, or sometimes 2 of the judges, would be appearing on a TV screen. And so you're just sort of used to arguing or explaining issues to someone on a TV screen. So it wasn't a big transition, in other words, when we went all virtual.
Right. Do you find it's not as effective, or I guess it's a level playing field, so both sides have the same limitations? If it's not effective for you, it's not as effective for your advocate. I mean, what do you think?
I actually have not found much of a difference, and because I can still see the faces. I mean, it's where I found it's less effective is when the Federal Circuit went virtual, then they were doing hearings by phone, and then you can't see the judges' faces. That, I think, was a big handicap. I think for everybody. Again, it's a level playing field, so it's not like it was a big deal. But to me, I kind of need to see the face of the person I'm talking to, so I can understand. Are they understanding what I'm saying? Are they believing what I'm saying? Are they skeptical about what I'm saying? Those things come out in facial expressions in a way that you really can't get on the phone. And you get that whether it's a virtual hearing or an in-person hearing. So to me, I don't think it's that big of a difference, honestly. And doing them virtually, I think, is fine. Some clients prefer in person, and so when that happens, we push for it and do it in person.
Do you miss anything about being just district court trials? Either, like you said, the damage or other aspects of litigation, or you're happy with just focusing on the PTAB stuff?
I don't know. I don't miss district court practice at all. So yeah, I'm quite happy to present all my cases to the PTAB. The difference in district court, the teams are bigger in district court, and so you get to work with a bigger team, and that can be fun. the PTAB teams tend to be 3 or 4 people, so it's a lot of a smaller team. But that said, it's more intimate, so you get to know each other better, and that's good. But other than that, no, I miss nothing. I don't miss going to trial, setting up in a war room for a month at a time, some hotel someplace that I probably don't want to be. No, I'm good. I'm happy to do these from my home.
What about your future? Do you see yourself doing anything else but being a lawyer or patent lawyer? Could you see yourself doing something else at some point?
I never say never, but nothing has appealed to me enough to want to switch careers yet. I think, I went into this career because I liked technology, I liked argument, and I still do. I think I'm still improving my skills, so I don't think I've plateaued, right? And there's still more for me to learn and get better. At some point I'll probably stop, and then I don't know, either retire or do something else, I guess. But there's nothing right now that I would say is on my agenda for an alternative career path. If I were to do anything at all, it would probably be something totally different, become an entrepreneur and explore something else.
Yeah. Well, Eliot, it's been wonderful chatting with you. I really appreciate your taking the time to tell me about your career. And if you do decide to try something else or be an entrepreneur, please come back and tell me about it.
I'll certainly do so. You'll be the first to know. Thanks, Richard.
This is Richard Hsu and Eliot Williams. Thanks.